Good evening, everyone. H-1B cap, multiple registrations, discussions number 2, and focusing on opening up a debate about what options do employees or employers have in this dilemma. 700 plus thousand H-1B cap registrations, we all know that. 400,000 multiple filings, not all of them fraudulent for sure, but some of them are, and USCIS have said that there are multiple dozens of companies, small companies, have colluded the system and they plan to go after them. I'm Sam Shihab.
I'm Brian Burke. It is Monday, it's 6 p.m., and I think we have a really good conversation going. One last week where I said I think I can continue this for an entire hour. Well, we'll have another half hour to talk about that. And we'll, of course, take your questions when the time comes. Stick with us. Wrong button.
All right. We're not going to go over what happened, maybe just a one sentence or two to give foundation.
Yeah, last week we talked a whole lot about it, but basically USCIS says that companies got together and colluded with one another to do multiple registrations for people to increase their chances of selection in the cap case. And last week we talked about a little bit about the history of this, how we got to this sort of point in the system. And basically companies who are tainted by this, one, they're going to expect to see it in their H-1Bs, and we talked about the green card implications as well. But really, the people who have the serious issue right now is people who are relying upon those H-1Bs from those companies to change status, come to the United States, start their life in the United States. And that's what we're talking about.
And just to recap, we think that the system was so not well thought of that it created this opportunity, and probably lack of aggressive enforcement early on. Because when people followed the rules, the other guys who broke the rules bragged about,
giving them high fives and pats in the back.
And then we saw these numbers increase every year into a blowing out of 400,000 duplications.
Yeah, everybody who was successful said, come on in, gang, the water's fine. And it turns out, there's some piranhas out there in the pool.
And USCIS says, we're going to go after companies now. So what are my options? So we're going to break down the various parties to this equation in various scenarios and talk about, what to expect.
Yeah.
The one that I would like to dispose of right away is the people who perhaps broke the rules, employees that broke the rules, but they were not selected notwithstanding. So these people, they broke the rules. They've maybe had the same job and they were shopping a job.
Yeah.
And
to a lot of people.
Contacted a lot of companies and they got multi-registered. But in today's, it's weird how we would say it, they were lucky not to be selected.
Yeah. Those folks, USCIS has broadcasted they're going after companies, and practically speaking, the logical expectation is they'll go after people who got something like selected in the cap or H-1B status that USCIS doesn't believe they're entitled to. So those folks who weren't selected, I guess my level of worry for those folks is really quite low.
The lowest on the list. So those guys probably got lucky and
yeah, not zero, because I'm sure you've been in a green card interview where somebody's been in the United States for 10 years and then the officer says, hey, what about XYZ that happened 10 years ago? And then that can snuff out somebody's immigration process right there. But right now, as it is, I don't expect somebody who went down that road and didn't get selected to really have a problem. Practically speaking, there's not a real process for going after those people. Those people didn't sign off on cases, that sort of thing.
So in my book, they're the lucky one not to be selected.
Yes.
How ironic, right?
So yeah, who then is to be worrying about this?
Well, yeah. So the first cut, in my opinion, the first cut of people that should be worried are the people the company owners first, who aggressively multi-registered with multi-company.
Fully agree. If you read, the news articles around this, people with inside sources from USCIS is a great. I think it's Wall Street Journal article says USCIS believes that it's small names you wouldn't have heard of IT companies that are their target, and those are the ones I'd expect to be going after.
So it would not be inconceivable. So that's a double negative, right, in our business, which is not a good thing. It is likely.
Yeah.
It would not be inconceivable that these companies who aggressively multi-filed, probably USCIS will go after them. It doesn't matter whether they file H-1Bs or not.
Yeah.
I think if you rolled 50 plus names on 4 or 5 companies, you probably are going to get a phone call from USCIS or a visit without even filing an H-1B.
Yes. I mean, I can't help but agree. I mean, any sort of investigation like this, we were talking earlier, who are you going to go after? It is the easy fish,
That's the easiest catch.
Yeah, they're going to pull their database of registrations. They're going to find the companies who's registered the most folks who they haven't heard of, and they're going to look into those things, and they're going to do some basic due diligence, and they're going to find the people who they think are the real egregious, violators.
Yeah.
Yeah.
And they did it last year. They'll do it this year. They'll look at payment systems, how you paid these multiple companies. They look at FedEx account. They look at if there's a common attorneys, common city, common ownership, common statutory agent, common phone number, common anything.
Yeah.
And they build a case.
Yeah. The one other thing I was thinking of, if they another way they might pull their database is look by the person's name. If they find somebody, pick a person who's the most registered person on the planet, that's a person I would be looking into, and I would look into who registered them, and look that way. Kind of a different approach on the search, but still.
So that's a good search. So you will rank how many multiple filings a person made, and from 1 to 200, and this 1 to 200, you're going to look at the companies and that person.
Yeah. Yeah, I think I'd be interested to see who is the person who's in the cap, who's been registered the most times. I think that would, I'd look for I'd look by companies, of course, but I think I'd be very interested in that theoretical person who's registered a whole lot of times. I wonder how many that is.
100 times.
I don't know, Sam.
It could be.
Will we ever know? But perhaps it really could be if you gave your name to a company, a couple different pools of companies, for example. So. Okay. One thing about time frame, what are they really looking into? So we have we are aware that USCIS has issued noirs, RFEs based upon registrations from last fiscal year 2023, and people are getting those right now. And obviously USCIS has broadcast per this fraud notice that they're going to be going after them in the fiscal year 2024, the one we're going into right now. So that's. It's not impossible that they can go look further back into prior years of electronic registration, but per the data we've seen, they don't think there's a bigger problem in the prior years. So,
but for companies that get investigated, I'm sure they're going to look at their prior history.
This is a very good point. So, where's the big risk factor? It's companies. There's broadcasted they're going after companies, and it's probably going to be their activities. But you're right. Last couple of years is the most obvious point, but you can definitely go backwards because they want to open a fraud investigation to a company. Yeah. The world is their oyster.
Yes.
So we have some scenarios that we want to talk about, right?
Okay.
So let's sort of put one of those up on the screen here. There we are. So we call this one the egregious employer. Employer A collects your information needed for registration and registers your name together with several other sister companies just to increase your chances of selection.
And this is the classic multi-registration.
Yeah, this is what USCIS, it seems to be what they're going after.
So what to expect in that? So this happens sometime with the employee's knowledge. It happens sometimes without the employee's knowledge. And it also happens sometimes with some employees knew about it and other employees don't know about it. And in that item, options available.
Yeah.
The employer first.
Well, the employer is going to expect to really see, get notice of this through either RFEs on pending cases or NOIDs, notice of intent to denies, or noirs on approved cases. So I guess I'm kind of assuming the case has been filed, right?
So let's take a moment to explain the difference between a notice of intent to deny, NOID, a notice of intent to revoke, NOIR, and an RFE.
Okay. RFE. RFE is a request for evidence, and a request for evidence is USCIS, to sum it up, saying, hey, we think we can approve this case, we just perhaps need a little bit more information. Notice of intent to deny.
Time frame on the RFE.
RFE, typically they will give you 87 days on an H-1B RFE. And I would note that RFEs come before a case has been approved. So this is a case that's pending with USCIS.
And USCIS can give you as low as 30 days.
Yes, they can. Speaking of giving you as low as 30 days, that is typically what you'll get on a NOID, a notice of intent to deny. Notice of intent to deny, I sometimes call it an RFE on steroids. It's, we think that we can deny this case. We are pretty sure we're going to deny this case. We're intending to deny this case. We're going to give you an opportunity to respond. Maybe we have it all wrong, but we are intending to deny this case. Here's your opportunity to respond. Typically give you 30 days to respond. And this is, again, notice of intent to deny is before a case has been approved, while a case is still in process with USCIS. Once a case has been approved by USCIS, so congratulations, your H-1B cap has been approved by USCIS. USCIS still has the opportunity to take an approval away with a notice of intent to revoke, or NOIR as we will call them. Notice of intent to revoke usually comes with a 30-day notice, and basically they will typically say something along the lines of, hey, we have come upon new information that suggests to us that this case was improperly approved, that you weren't entitled to the approval that you got. Tell us we're wrong, give us evidence why we're wrong, otherwise we are going to revoke this approval. Okay. So,
in the context of the H-1B fraud,
yeah.
This year's cases, more
to
than
be filed cases, yeah.
To be filed. Once they're filed, they're likely to receive a NOID.
Yeah, yeah. NOID saying
Notice of intent to deny.
Yeah.
30-day notice, we're mad, we're angry because you multi-registered under scenario 1.
Yeah.
And we know that company B, company C, company D had 80% of the same registrants, and you have the same statutory agent.
Same owner, same HR signatory, something along those lines.
We find enough commonality between you that we feel that you've colluded. Please respond and clear yourself.
Prove us wrong. Yeah. So if those cases get filed, that's really the path that you're on. You're going to get the employer is going to get an RFE, more likely a NOID. So one thing we have to bring up here is it's possible that the employees will not know that these have come in. Why? Because in an H-1B filing, the employer signs off on the H-1B filing. The employer gets the RFEs or NOIDs or notice of intent to revoke. It is a gaping hole in the H-1B system that the individual doesn't control the case, that the employer gets notice, they don't get a courtesy copy in the mail, and practically speaking, the employer can hide this from somebody.
The employer, well, yes, in theory, but in the context of a small company, and there is an HR working there, it's going to be very difficult to keep the lid on something like this.
Yes. So this RFE or NOID more likely comes into the company. What's gonna happen?
Yeah.
Obviously, there's an option to there's an obligation to respond. Well, an opportunity to respond. If an employer is in fact a wrongdoer on this one, they know they've done this. I worry about that employer because if they respond and try to deny it, they can honestly dig themselves further into their hole of alleged fraud. Would you agree?
100%. So this is a moment where the immigration attorney will recommend to the employer to engage a criminal attorney with them.
That is critical, yes.
At that very moment before you respond. And again, it becomes very important to make sure that the response is run by and reviewed by that criminal attorney, because the consequences can be serious.
Yeah, I would emphasize criminal attorney because USCIS has broadcast that they're going to be doing criminal referrals for these scenarios.
Yes.
So what can the individual do then, Sam? If I've already said the employer gets the notices, they're in control of this case, what does the individual do?
Not much of an option for the individual, because the individual has the idea that you can save your H-1B is not completely gone, but slim.
In this scenario one where the employer has engaged in blatant multi-registration on your behalf.
Yeah, because there's no employer. The employer now is almost getting wiped out.
Yeah, they are in panic mode. They are trying to save their own butt, and their response is going to be to anything that can do that.
So if somebody comes to you and say, "Here's what happened to me, represent me," what would be the first thing you would do?
I would say, gee, your employer is in control of this show. I would expect that you probably can't get your voice into this proceeding as it is in this RFE or NOID response, because you don't have the opportunity to. They're crowding the wagons together to protect themselves.
Would you file a FOIA?
I think I would like to see that, and I think there's a reasonable request, a reasonable idea to try to expedite that FOIA with the government, because your rights are being disposed there. I mean, because let's talk about what's on the line here. It's not just it's one. There's your selection in the H-1B registration, right? There's it is possible if you are selected in the cap for USCIS to undo that in cases of fraud or misrepresentation. So that's you're counting in the caps itself. It is the approval of the case that's on the line, obviously. And then there's something else that worries me. It's, in theory, if the employer can save its butt by pointing their finger at you, I wouldn't, put it past somebody to do that.
How can they?
Very, very unlikely in a multi-employee, multi-filing scenario. So if you have, 10 employees have been registered 10 times across 10 different companies, I'd say fat chance of blaming the employee. But I guess the point is, you as the individual who's implicated and who's the beneficiary of the H-1B is not going to be able to plead their case in the context of the response. Unlikely, because the employer is very potentially your adversary at this point.
So I understand the odds are stacked against the employee. Yeah. I understand that, and you've made that clear. Yeah. What activities within that slim margin of success would you do? That I will tell you one or two myself.
Sure.
I mean, again, just to make sure, we're talking about an opportunity for success that's slim, but there's always lawyering to do.
Yeah, okay.
Right? There's always things to do as lawyers to try. Now, some people say, I don't want to spend money on this. It's too expensive. It's ridiculous. Chances are very low, and you have every right to do that. But some people say, you know what? I put so much effort in my career. I've been here. I studied my master's degree. I applied 3 years in a row. This is my last year in my STEM OPT, and I honestly would like to try to work this. So with that slim margin of error, of success, would you write a letter to USCIS emphasizing to them that you are innocent, uninvolved, and you should not be penalized because of that?
Yeah, I mean, yes, and finding a way to get that in the record could be range from getting your letter in with the employer's response, maybe sending a separate letter to them on your own, or filing some sort of court case to intervene. All of these are potential options, but
would you be able to intervene in court during an agency stage? Probably. I mean, you can try because you don't have a method to intervene. It's very unusual to do that.
Well, the point, I guess the point is, I already railed upon it and saying, yeah, you're not involved, you're involved, but they're potentially disposing of your rights, because potentially they could say in there making a finding of fraud for the employer, they could say, also, we think this employee was involved, and make a finding that you are inadmissible to the United States. And that's definitely disposing of your, your personal immigration rights. And fundamentally, in everything you do in U.S. government, you have the right to respond. If any sort of allegation comes up against you, you should want to respond. Well, you should want to respond to that. And it's a hole in the system again that you don't have a very easy way to do it, but you should try to find a way, because a finding that the employer engaged in fraud or misrepresentation is a problem for the employer. Fines, criminal penalties, et cetera, the company gets really badly hurt. But a finding for the individual, if they submitted fraudulent or engaged in some sort of fraud, immigration fraud, is that you can be deemed inadmissible to the United States, meaning you won't be eligible to come back, or you probably won't be able to get a change of status in the United States. And that's a problem, especially if you don't know about it.
Yeah. So I guess there's a fundamental question, is when we've talked about it before we got on the air. So there is a potential different decision you make if you find out that the employer committed fraud before they file your H-1B,
Yeah.
As opposed to after they file your H-1B. Yeah. So if you find out that the employer engaged in fraud before you file the H-1B, this is a moment where you have to decide.
Yeah, well, I mean, that's a great point. If you know this employer has engaged in fraud to get your H-1B selected, and then you go ahead with that filing anyway, that's how is USCIS going to prove that as a side, but that's when it upticks your chance of being implicated in the fraud yourself. That if the government has some way of proving that you knew that it was a fraud, well, congratulations, you're implicated in the fraud as well. And that's when I might say, gee golly, maybe you need to be,
But if he's innocent and he wants to take a chance, he heard that the employee didn't know enough, or she didn't know enough about the extent, because employers sometimes, we've filed 3 different people. You may not have enough information.
Let's maybe take a step back. We're talking about criminal bad things, but there are fundamental holes in USCIS policy, and they have proclaimed in a writing on a website, which is USCIS says their forms have the force of regulation, or what is it, regulation or law, and they add it to their website. You can't collude with another company. All of these things are things that can be challenged in court. What is the meaning of these things? What is permitted and what is not permitted? And these are things that some company surely is going to be litigating with the government as they try to save their butts, as well as all of their H-1B registrations. I think these things. This is uncharted territory is the bottom line, and there is.
How can it be so criminal that you get together with another company and you filed 50 names, and now you go to jail? That sounds crazy.
Yeah,
I mean, I'm not condoning it.
Yeah, but
that sounds crazy that this is a crime. You're now equating these people with thieves and rapers and
I think the one of the arguments these companies make is the bottom line is gee golly, guy and gal A, B, C, and D, and E, and F, all those people have important skills that I know that I want, that any one of these companies would be they are be an asset to any of these companies. They're skills in demand in the United States. As long as I can have them working here, I can make money in that endeavor.
It's one thing to reject all those cases,
but to go after those people.
And something else to pull somebody and put them in jail. Yeah. So for me to say, multi-registrations will result in a revocation, or how about blacklisting you from the H-1B program?
Yeah, sure.
Blacklisting your name. You cannot be an officer. You cannot be an officer or an owner of any company that engages in the H-1B filing for 5 years. That's, I understand. But locking you up, that's ridiculous.
Well, maybe these are how these get settled. I don't know.
I don't like those guys either. But to just the idea, because what happened is it destroys the whole program. Now you got innocent people who applied okay, for the H-1B visa, who are caught up in this, whether they made a mistake in judgment, whether they didn't make a mistake in judgment and they played it straight.
Yeah.
These people now, they're saying, I don't want to apply for this H-1B visa.
Well,
Did I do it wrong? I'm not so sure. Did I double register? I went to these companies, you know.
That's what drives me mad, and that's kind of the point of this presentation. It's anxiety out there. Everybody's as soon as this policy was announced, I had 3 different emails and a phone call saying, hey Brian, it's just scary stuff that they're putting out there, and I don't like that they're saying vaguely we're going to go after people. And there hasn't been an official announcement. I don't think I've seen any. We've been on the lookout for court complaints, press releases about that sort of thing. I haven't seen anything yet.
And why would? And again, we're digressing because we want to talk about people's options. But the thing that for me, when I flipped over and read the Wall Street Journal on the day it was released, I said, why USCIS is coming out and say we're going to go after people?
It's a great policing strategy, right?
Intimidation.
Yeah.
It's intimidation. It's like the mayor coming out and say, last night, people were out there doing this, and that. We're going to go after them. Scares people because people say, is that me? Were they talking about me? Is he talking about me?
Yeah.
Why is that intimidation in the process is so unhealthy?
Yeah,
it's so unhealthy.
I would rather them just say here's our list, here's our criminal complaints.
My option as an H-1B registrant who heard, and this is where the problem is. So now before you file your H-1B, somebody come to you and say, your employer, I heard your employer multi-registered 100 cases. It could be all BS. It could be a lie. Yeah. And you say, oh my God. And you call the employer and you say, I just heard from somebody that you multi-registered. And the employer says, no, I didn't multi-register. They hang up. Somebody else goes say, I have heard your employer because it's going around right now. This employee, and the employer maybe did not multi-register.
Well, all it takes is some jerk out there to say, company A, I heard they're skeezy. I heard, and you can kill somebody's livelihood, their business, their reputation that way.
And kill the H-1B employees' chances because now the employee is saying, I'm not going to file this H-1B. Yeah. I'm not going to file it because I'm going to get sucked into it. And here's all the work you've done as a human being to go to college, to come to America, to do the right thing, to pay your dues, to go to your master's program. And then here's your chance, and now you're afraid to take advantage of it. And that is the problem with what happened. So what do you advise this person? Don't file? I can't advise him not to file. It's ridiculous.
Yeah, I mean, the bottom line is I think anybody you're right. That person who heard a rumor about their company,
unsubstantiated. What do you do?
What are your options? That's where I say I don't have a great option. I say
we don't know.
As an attorney, we say here's what you have down the road. You may have you and your employer if you might have a big old fight in court, and there are government policies here that haven't been tested. It's going to be interesting to watch these cases in court, and I'm going to be on the lookout for them.
My advice to this person is to call the employer and say, here's what I heard, and the employer says, no, I did not multi-register. Go ahead, file. You're good. I would just get on my email and I'm going to tell the employer, I'm going to send you an email to confirm that because I don't want to get sucked into it. I would write an email and say, I'm very sorry. I don't want to be involved in this, but I've heard from multiple sources, this is what they're saying about your company. You need to go out there and make sure that those people are not saying these things about your company, but I am trusting you that you haven't done it. And you're aware that I have not been involved in any of these actions. And I'm relying on you to file my H-1B because this is my future is in your hand. Can you please confirm? And get the email confirmation.
Yeah.
Keep that email in a safe place and file.
If things go good, they go good. If things go bad, at
least you have that email.
You're going to save yourself from that personal finding of fraud or misrepresentation.
Improve your chances, right? Yeah. Because USCIS sometimes does things because you don't have a chance to even intervene unless maybe you file something in court asking that you're going to be irreparably harmed if you have not being allowed to intervene in responding to this allegation of fraud that involves you.
Yeah.
So I would file a FOIA probably and see if I can get this information too. Okay, so now what's the scenario two? So we ran out of time talking about the first scenario. Let's talk about the employee who multi-filed.
Yes, so there it is. Scenario 2. Scenario 1 was the egregious employer. This is scenario 2, the egregious employee. Employee emails all the employer contacts he or she can find regarding H-1B registration with their resume and details needed for CAP registration. He plans to file H-1B based upon his consulting assignment with whatever employee gets a positive result in the H-1B CAP. So I'm working with a big bank. I have, it's a consulting assignment. I know there's lots of consulting companies who would love to make a little bit of money on my assignment. I'm gonna go to company A, B, C, D, every letter of the alphabet and say, guys, drop me in the H-1B CAP, and if you get selected, I'm happy to file a case with you guys. Fantastic, So USCIS, in everything we've seen, doesn't seem like they're really going after the individuals, and it seems like this individual might be harder to catch. For them to catch in their net. Fundamentally, they said they're going after employees, but as I mentioned at the beginning of this, if I were the guy searching the registration database, I would be searching for, who's the guy or gal with the most H-1B registrations on their behalf, because that person sure is interesting to me. But that's the scenario that we're talking about. So what are your options then?
Well, number one, multi-employee registration with somebody who is shopping a job, that's basically what you're talking about, is difficult for USCIS to catch.
Fully agree.
USCIS is going to have its tummy full with a lot easier fish.
Yeah.
The multi-company registration, where you can catch companies who are doing it by the bundle, okay, or where the energy will be spent, in my opinion, USCIS.
Yeah.
Those guys who are now. If you floated that job to 30 different companies, they're going to go after you, my guess. But if you floated that job for 2 or 3 companies, you stand a lesser chance of being caught, in my opinion.
For sure. One thing I got to say is, I'm not still entirely convinced that this. First of all, when the employee doesn't sign off on the H-1B registration, right, and they don't sign off on the H-1B petition. So second of all, I think that sort of gives more weight to how is USCIS going to go after you? You haven't signed off on a registration and you haven't signed off on an H-1B. What fraud have you engaged in?
100%.
Additionally, this theory of it's wrong for an employee to take their consulting role, which is important for them, to multiple companies. This is based upon a case we talked about last week, matter of S Inc., which is a USCIS administrative appeals decision, which when it came out, and I think we still agree today, is a bad decision. It's basically one that says companies can be considered related if they file essentially the same H-1B case based upon the same role. That's something where I'd still be interested to see how that holds up in an actual court.
Well, not in a conservative court that follows the strict constructionists. If the court follows the law strictly,
you're talking about agency deference again, Sam, right?
Right.
Yeah.
Yeah, exactly. So this you're right. I don't think this is really ultimately is going to hold up in court. But I don't know how many years it's going to take.
Yeah.
To turn it. Maybe this is the year. But you're right. This practice is extremely questionably to be improper.
Yeah.
Legally.
Yeah.
But people don't care to hear about that. What people want to hear about, what do I do? Well, what do I do? What are my options?
Well, I bring that up because you fight it in court. If you're already in, the case is already filed. If you've already picked the winner and the case is filed, you might get that RFE, NOID, or if it gets approved, a noir later.
But this is a low chance.
Yeah.
And this is a fight.
Yeah.
And it's hard for me to make a recommendation to file or not file in any of these scenarios. It really is going to be a very personal scenario. All what you can do is what the potential consequence is going to be. If you floated it to 2 or 3 companies, I would be a lot less concerned about this thing being
Again, I don't think it's possible that, I mean, the employers, the definition of collusion of a problem has been, in this scenario,
Yeah.
I'd say, you know, maybe you haven't, there's a good argument to be made that you haven't even reached the definition of that sort
Or that
of
collusion,
Yeah.
yes. I agree with you, yes.
Yeah.
It could be that the employer, the second and the third and the fourth employer did not have a bona fide job for you to apply in the lottery, as opposed as to you colluding with them to float a job.
Yeah, those guys shouldn't be, the government coming saying, you guys shouldn't have filed that cases if you didn't, have the work.
Ultimately, the employer could be more in trouble than the employee.
Yeah.
All right, so we've taken too much of people's time here.
It's a really ripe topic of conversation.
And we can talk more about this forever, but is there going to be a second lottery?
It kind of increases, you know, if we're sitting here saying there's a lot of people who probably aren't going to be filing that cap case because they're either the company doesn't want to support it because they engage in some dubious dealings or the individual backs out, it kind of leads to that possibility, which is, well, and you know, the bottom line is if USCIS doesn't have enough cases to get through 85,000 slots in the cap in the year, they can do another selection. So. Yeah. Remains to be seen.
I'd say it's a good chance.
It increases the chances of it for sure. Yeah.
What month?
Last time I believe we saw it in August. Okay. Yeah. Basically, the cap filings. The first deadline is June 30th, and you know, give them about a month to cool down at USCIS.
A month to process the noirs.
Yeah.
You're
right. That could delay it.
To deny noids. It's going to be a lot of noids. So that's 30 days.
Yeah, I mean, but
this is somebody filed on June 30th. But you know, it may take them a month to issue them.
I mean, USC, it could take them a long time to resolve these cases, and
so it could be a late registration.
Yeah.
September.
Yeah.
September late registration, second registration.
Well, I mean, they have. I mean, as long as. It'll be very interesting to see. I mean, historic years in past, I remember doing H-1B cap cases in January of the next year. So you're right though. They have to, in order for them to know what additional selections they have to make, they have to dispose of these cases, and having to do noids takes time.
Takes time. So this is our discussions. What are my options? Obviously, more questions than answers, unfortunately, but hopefully we've answered some questions for you. When we come back, we're going to take your questions. This is the time when we answer your questions, and we are going to take your question as they come. Just please remember, there is no attorney-client privilege by creating or relationship. That's by answering those questions. Always consult with an attorney of your choice before you make a decision on your immigration case. Don't rely on short answer to a short question to decide the future of your immigration case. And we will take the first one from?
Here we are, Parth Rathor.
All right.
So from Parth Rathor, currently I'm on H-1B with approved I-140 on EB-2 as well as EB-3. I started using my green card EAD last year. Now if I want to file another petition for EB-1A, can I do that being on EAD? Please advise. Parth, I think that's a good question with a pretty straightforward answer. It is possible to file another I-140, hypothetically, in the EB-1A category while you have a pending green card. The limitation is, I think, if you wanted to file another adjustment of status, that's not going to be possible because, generally speaking, employment-based green cards require you to be in status. However, a transfer of underlying basis from your current EB-2 or EB-3 green card to an EB-1A I-140 is something that's definitely on the table.
Absolutely. I agree. Good answer.
Yeah. And
Parth Rathor.
From part two. Because I no longer have H-1B and I started using my EAD for employment. So I think I was presuming that in your answer there.
Yes.
Parth.
Yeah. Excellent.
Item 2.
From Bragov. I'm working on STEM OPT with June 2024 expiration date. I have an H-1B counselor approval. Can I travel outside the U.S., get H-1B stamped, and enter the U.S. on F1 visa to continue working on STEM OPT until June 2024? So you have an H-1B approval, and you're on a STEM OPT. You would like to come back on F1 and continue working. Theoretically, yes. Practically, there may be issues because USCIS probably would want you to switch to an H-1B, and they don't want you to give you both F1 and H-1B.
Well, it's H-1B consular approved though. So I mean, he hasn't said he's going to change to.
He has an F1 stamp on his passport already.
Oh, I see. Oh, okay. He wants to get H-1B.
Can I travel outside the United States, get H-1B stamped on into USA on an F1? Okay, he has a stamp on F1.
Yeah.
But he wants to get an H-1B stamp and then enter on F1.
Yeah.
So there is a good chance when you get your H-1B stamp, there's a great chance that they're going to cross out your F1 and cancel it.
Yeah.
But if they do that, then you have to enter on an H-1B. If they don't, you can most certainly select to enter on an F1 and process with it. You need a valid I-20 and
you're gonna need the EAD if you're using to it.
So in theory you can do it, but I would say more likely if you get an H-1B stamp.
Took me longer to get there, but I think I agree with you. The in theory possible, but more likely not.
Yes.
Yeah.
Yes. All right, but that's a good question.
Yeah.
Can I have both F1 visa and H-1B visa on my passport and choose to enter USA on F1 visa stamp? Again, the answer is in theory, yes. You can have both. I would say most likely that USCIS will cancel one and give you the other one. They shouldn't, but they like to kind of control the type of visas you have on your passport.
Yeah, I mean, H and Fs aren't incompatible. You can have
all the time.
Yeah. There's no immigrant. I mean, number one problem for Fs are immigrant intent, and H doesn't mean immigrant intent. But yeah, I just foresee that having a frank conversation with a consular officer saying what's going on here, and then your F1.
You could during the interview, if you find a patient officer and say, I'd like to get an H-1B stamp now, but I'd like to come out on an F1 visa, finish up my OPT because I don't want to burn all my H-1B time. But the risk in doing that is they may say, here's your passport, come back when you're ready to get your H-1B visa.
Yeah, that's exactly what I was thinking. It's like you're going to get a pissed off U.S. Department of State office saying, why are we here then?
You're shopping visas and you're coming to me a little too early. Why are you coming to me to get an H-1B visa when you're not intending to be on H-1B visa?
You apply for an H-1B visa 6 months out.
Not a good idea. Not a good idea. I agree. Yeah, but that's an excellent question.
Yeah, a good one to talk about. So from Karthik, in my biometrics appointment, I got noted as biometrics for I-765 and I-485. Do we need biometrics to be done even for I-131? So I have an answer to this, and I'm curious to hear your take on it. Anytime I've seen a biometrics notice lately, it's always said it's for I-765 and I-485, and it wouldn't surprise me if they needed some biometrics for an advanced parole, but I don't believe I've seen them on on those biometrics. I don't think I've seen references to I-131 on.
I don't think biometrics is required. I stand corrected. Biometrics is required on I-131s. So I-131 form is a multiple use form. Mm-hmm. It's advanced parole, reentry permit, and they do require biometrics.
So as a practical matter, just because it says, I-765 and I-485.
It doesn't mean that it does not include I-131.
Yeah. For example, it's possible for USCIS to reuse biometrics from a prior case for your I-485. Those of you out there who have gotten a I-485, hey, we already have your biometrics on file. Notice
it won't even be a prior case; it will be contemporaneous case.
Oh yeah. In this scenario, I'm just talking about that.
Yeah,
scenario.
Most likely they're going to use the I-765 biometrics for the I-131. For whatever reason, they have it written that way. It makes no sense. But they could call you for a separate biometrics. I-131 does require biometrics, but by doing it through the I-765, you probably will not be called for the I-131. But the government has done stupider things before, so you never know. Yeah.
So, Bargov Paladugo again. Do U.S. consulates cancel existing F1 visa if I go for H-1B stamping? And well, we had our talk on that subject. It's resounding. Maybe so.
Yeah, sorry.
You're fine. And yeah, there's somebody else with the good name of Optimus Prime there in the audience saying, I think you might have a problem with that as well. Yeah. So from Avinash Kumar, hello, I filed my H-1B from my main employer and an IT consultancy firm as well, one application. I got picked with my main employer. What documents should I be ready with just to be safe? Bottom line for me is, first of all, are you particularly worried about this person in this scenario, Sam?
I was reading into it, but it says one application, so that's good.
Yeah.
So there's no multiple filing.
Yeah. Well, that means there's two companies that have filed, but one of the things we talked about earlier, Avinash, is that USCIS seems to think there's a problem with same job with multiple companies.
May not be same job. I mean, you're assuming that.
I'm assuming these are different jobs. One is his main employer, one's an outside company, an IT consultant. Yeah. I guess if those companies are offering distinct jobs, I'm not too worried. And basically, if that IT consulting company that didn't get selected has an offer of employment to you that's different from what you're doing right now, there you go.
But your reaction to the question, I want to highlight, is the problem with what USCIS has done.
They've scared this
because everybody now is on their edge and paranoid. Yeah. So I'm assuming Avinash Kumar did the right thing, and it is not related.
Yeah, different companies, distinct offers of employment, which is totally allowed.
Yes. Yeah, totally allowed.
Yeah. I guess, take one thing away from this presentation. It's distinct offers from different employers are allowed. And in theory, I'm sure there's some guy out there that is super special, has 5 or 6 different offers from employers, and that guy is allowed to be registered 5 or 6 different times in the cap.
Yes. And the good news by the main employer, so I think it...
what are your...
I think you have to ask the employer, are we comfortable with going forward? Is there any multiple filing problem? Of course, you don't want to offend them, but saying, and unfortunately, the whole world is upside down now, I just want to ask the question. Yeah.
For me, I need documents from that other employer. You obviously have the support of your main employer. Anything you had from that other employer to support that said, hey, we had a different job opportunity for you, distinct from what you're already doing with your main employer, is something I would keep in my pocket. I was doing this. This is me working in-house as a software developer for my main company. This other company was looking for consultants to help them on their client on a project. Different things. Yeah, that's really what I want to do.
And this is why not all 400,000 duplication are fraudulent. There's a lot of good guys who filed because other people were filing 2 or 3 and 4 and 5, and everybody, you're encouraged to do that properly and legally.
Yeah,
as our friend Kumar here has done.
The reason why there's so many IT companies, filing, multiple registrations, be it right or wrong, is because there's a demand for these folks in the United States, as evidence of the fact that Avnish here has multiple job offers.
No, that's not the reason, Brian. With all due respect, the reason is because the prior year people double filed and weren't caught. Yeah. Because if everybody followed the rule and played by the game, there's demand, there's demand. You do the best you can, you apply, but enforcement will lax. And people who gamed the system, or some people who gamed it, or a lot of people who gamed the system, got ahead the prior years. Well, sure. Now, everybody's doing it.
Well, I still say, the bottom line is, who are most H-1Bs done for? It's done for people in the IT and engineering and industries, and that's where the demand is, and you shouldn't be. Yeah. You're just sort of highlighting the point. There's lots of demand there, Avnish.
Precisely.
So,
Madi, is it possible to renew F1 status after applying for 485 by transferring to a new school to get a new program in the same school? On I-20, ? On I-20, students should sign that he wants to stay temporarily. So, Madi, it's an excellent question. The F1 visa is a visa by which you promise to return home at the conclusion of your study. An I-485 petition is a statement of intention to remain in the United States at the approval of the I-485 on a permanent basis. They are not consistent with one another, and therefore consulates normally do not approve an F1 visa stamp for someone with a pending I-485, period. However, having said that, I have seen cases that have been approved. And what I normally see is people who've been here for a very long time, kids who've been here for a very long time in the US, and they go back home and they visit grandma and grandpa and they want to come back and they're on a 485. It's clear that it's not 100% consistent with the F1, but it's also clear that the situation was not contemplated in the law very well. And if you have excellent grades and you attend a good school and you come out very straightforward and explain it, I have seen it get approved.
So you're talking about going for stamping at the consulate, right?
On an F1 visa.
I always thought maybe this person was talking about a different scenario. Basically, hypothetically, somebody ending the bachelor's level program and wanting to pursue a master's program so they could, maintain their F1 status while their I-485 is pending. And that won't require a new F1 filing. I think basically it's, hey, maybe can you go through the transfer process at schools while still in the United States without, running is it possible for them to do that? And that's, fundamentally you're right. No matter where you are, if you're outside the United States or inside the United States, an I-485 runs afoul of your intent requirements for an F1 visa. I can't help but think that maybe the SEVIS system will ping and say, hey, you have a pending I-485, we can't, process this transfer.
That would require an I-539?
No. When you're going from like a bachelor's level to a master's program, to the best of my recollection, you basically
with a different school, right? Transferring to a new school.
To a new school.
So a new school, there's a SEVIS transfer.
Yeah, and I don't believe that's a scenario that was not going to require an I-539, and there you go. So it's something which my honest answer is I don't know how the school is going to react to that. It's fundamentally the SEVIS system, which is a system that's controlled by ICE, which manages the F1 visa program, that would probably be determinative on that in my book.
Yes, but I think it's the same answer in that because they're inconsistent, you may have an issue. But if you are in a good program and a good school and having good grades, I think there is opportunities for them to overlook that.
Some flexibility, definitely, for sure. Sometimes I do get amazed by USCIS's ability to be nice on things where they probably should.
Yes.
From Prasad Bodapalli. I've applied for AOS I-765 renewal and I got receipt numbers where I found that my first name, one letter is missing, which is missing the application itself, while filings have spoken to USCIS Tier 1. Looks like there's a Part 2 here. Following up, just USCIS customer care created service requests for the same. I got called for biometrics because of my first name missing letter. My spouse, they reused her old biometrics. Do you want me to cancel my I-765 renewal and reapply fresh as my current application where my first name, one letter missing, which is my mistake? Please advise me on this regard. So I think this...
Well, first of all, we don't make recommendation to cancel or do anything. You do not make decisions by listening to us. You got to talk to your attorney. That's the first thing.
That was the very thing I was going to say first as well. Generally speaking, I think. You want to? Shall we leave it at that for this one, or I can give a little bit of an answer here.
I think I could have a little bit of an answer deserving. Yeah.
Generally speaking, USCIS is not happy to correct typos on forms when it's the filer's error is the bottom line. So I foresee a potential world where USCIS approves an EAD with a wrong name on it, which could be a different type of nightmare.
And even if they want to correct it, it's a nightmare to correct, and they correct it wrong half the time.
Oh, getting USCIS to correct something is
it's just impossibility.
Call your drywall person, because you're going to be putting holes in your wall from where you put your head or your fist into it.
They're going to fix that letter and drop another letter down, a few letters down, and then you're going to say, "Oh my God, I spent 7 months." They fix that one letter and then they flip the U to an N or something like that.
We've both been traumatized in the past by asking USCIS to fix typos for sure.
How will USCIS know if I switch to I-485 EAD? So we have a whole video on how will USCIS know, but USCIS does not know you switch to I-485 EAD the day. There's no light that turns on, there's no red light, or there's no phone that rings, or a pager, or an automatic update to a computer, none of that. However, when you file a petition, the documents presented will show, for example, some information. Employer must correct or update their I-9 record to reflect your work authorization when you switch to an EAD. Your petitions, when you're asked your work authorization, you have to reflect that. So that's how they know. But the day you do it, the only person that knows is you and your employer.
Yeah.
And there's a follow-up. Also, is advanced parole and passport enough to get back into the U.S.? Well, the standard answer is the passport and advanced parole are enough to give you a chance to enter the U.S. The only person that is guaranteed entry in the U.S. is a U.S. citizen with a proof of citizenship. If you're a U.S. citizen and don't have a proof of citizenship, you're not guaranteed to enter the U.S. And therefore, does that give you what you need? Is this the basic requirement to have a case in which you can process an admission? Yes. An advanced parole and a valid passport for at least 6 months probably is what you want to begin with as a minimum. All right, the next one.
From SanFax, it's a multi-parter. Joined new employer on GCEAD, reasonably sure that job is same or similar. Employer is ready to file I-45J. What happens if I-45J gets denied, stating job is not same or similar? And as a follow-up here.
Let's get the follow-up before we answer that one,
Sir.
right?
Does it put the I-45 at risk? Do I need to find a new job immediately that is same or similar? So the scenario he lays out is, USCIS doesn't believe my job is same or similar. What is the likely result? I would say the likely result is, potentially a RFE or NOID stating that we don't believe your job is same or similar. I suppose in theory, as USCIS has been known to do on I-45s at times, that it's possible for them to deny a case outright. I would be very surprised and also very angry if they did that in this scenario. But realistically, I would expect an RFE saying we don't believe it is, because honestly, I think it's RFE or NOID is likely because you'll be given an opportunity to explain why it is. The bottom line is the person you're dealing with at USCIS, they are probably not very well qualified to determine whether job A is the same as job B, and that RFE or NOID can give you an opportunity to explain to them, everything that it is you do for a living and why the jobs are similar.
So that gives rise to whether or not you should do supplement J on day one.
Yeah.
It's our basic recommendation to do it. But if you have two job descriptions, you might want to run them by an attorney.
Sure.
To make sure that they feel how much they feel about whether it's same or similar. I had a consultation recently where the attorney advised that the job is not comfortable that the job is same or similar, and they ran it by me, the employer's attorney, and I had a different conclusion.
I had a consultation along those. Somebody talked to talked to his employer's counsel and said there's some risk, and talking about me to articulate what that risk was really from a different perspective, and similar result, really kind of. Yeah,
it's same or similar. So I mean, we've done them a lot, and therefore we have a certain level of confidence in our advice. I trust other attorneys' competence as well, but. Even attorneys looks like differ on this issue.
Yeah, I mean, one thing that I find that is useful is reading USCIS's policy on same or similar occupation. For those who aren't aware, it's a good read if you ever have an immigration anything. Read USCIS's policy handbook. Just search for your immigration topic and USCIS policy handbook. The reading's a bit heavy, but the chapter on same or similar occupation is one I've read like 20 times.
And it came first in a memo, and the memo is available in the PDF, 15-page PDF document, but it's not difficult to read, and there's examples.
Yeah.
Scenario 1, Scenario 2, Scenario 3. And as you read through the scenarios, you're going to develop a confidence or not confidence in your. One of the things that made me confident that this guy had the same or similar, because he had a managerial position.
I had one of those too.
And the previous one was not managerial, is to look at who he's supervising. So I asked him for a list of who are the people he is supervising, and it was people who are his prior position. Most of them, not all of them. That, for me, that's sufficient. The job is similar.
I had that same scenario recently, and it's nobody can give you a guarantee that they're going to take it well. But the bottom line is, if your scenario is written out there, it's really close to what you look like in example in their policy handbook. You can't really ask for much more.
Yeah. Mr. Kumar has a question for you, Brian.
Avnish Kumar once again. For a friend, if Frank can come watch us too, he's welcome. He had the last tempo on H-1B and is considering day one CPT to do a second master's and work with employer concurrently. He also has I-140 approved. Is day one CPT recommended in this case?
Well, day one CPT is suspect regardless.
Yes. USCIS, if you have been involved in day one CPT, USCIS often likes to issue RFEs asking about that in the context of an H-1B change of status case, for example.
Yes.
And with an I-140 approved, now, fundamentally, we're talking about things that conflict with F1 status. I think that having an I-140 approved is something the government could argue does conflict with your F1 status. It signifies immigrant intent. However, this person didn't sign anything to get that I-140 aside from an ETA 9089. Something to leave out there. So day one CPT, I think that's something you got to think about very carefully, and that's the sort of thing I talk about an attorney with before making a decision. And that's a pretty major decision with some risks and challenges involved in doing day one CPT.
Yes. If you have a pending I-45, EAD, and advanced parole, but maintaining your H-1B status, what happens if you leave U.S. and try to enter back on advanced parole? Can they still keep their H-1B status? So if you return on advanced parole and join the H-1B employer and continue working for them, you are on advanced parole, no question. You're not on H-1B again. However, you could extend your H-1B or amend your H-1B, amend and extend your H-1B with the employer or with another employer and get back to H-1B pursuant to a 23-year-old memorandum that USCIS says we will allow it. I think I answered the question, I hope.
Yeah, do they allow you to do it if you're from coming back to another employer?
I would join the first employer first, and then do
change employer.
Yeah. But I have seen it approved.
Okay. Yeah.
With a changed employer, so you can join back your employer on EAD. And then file a changed employer, and that's
the problem with not having a good regulations instead of relying upon a 20-year-old memo. Is that USCIS? I'm not even sure knows what their opinion is on this. And
what is the current family-based green card processing time for spouse of a U.S. citizen in California? Would you recommend this process for someone on EB2 with prior to the date of August 2013? There is no wait period for a spouse of a U.S. citizen green card application anywhere in the U.S. and in California.
Yeah.
And yes, I would recommend it for someone on EB2 with prior to date of August 2013. They should probably get an EAD and a green card within about a year to 2 years, and they can have both cases processed at the same time.
Yeah,
with that, we conclude today's presentation, Brian.
I think we do. Sam, I would note that it appears that we're off next week.
Ouch. So
Memorial Day.
Memorial Day. We will then see you in 2 weeks, 6 o'clock Eastern Time, to hopefully talk more about a topic of interest to you. Until then, you guys have a fantastic 2 weeks and a great